Good morning, everyone. My name is Tom Ryan. I'm the chairperson of the Michigan Judicial Tenure Commission. Pursuant to MCR 9.241, the commission is conducting a public hearing in the matter of formal complaint number 105, in re Demetria Brue, a judge of the 36th District Court in the city of Detroit, Wayne County, Michigan. The other members of the commission are, starting at my right to your left, the Honorable Monty Burmeister, judge of the Crawford County Probate Court, elected by the probate judges of the state of Michigan. Dr. Maxine Hakens Kane, one of two civilian members of the commission that is neither an attorney nor judge, who was appointed by Governor Gretchen Whitmer. The Honorable Thomas Cameron of the Michigan Court of Appeals, elected by the state's appellate judges. Judge Cameron also serves as vice chairman for the commission. Next to me is Dawn Eisen, elected by the State Bar of Michigan. Siham Adwad Jafar, the other civilian member of the commission, who was appointed by Governor Gretchen Whitmer. They just changed it. Thank you. I'm sorry. Judge Kiana Liller, judge of the Third Circuit Court, Wayne County, elected by the Michigan Circuit Court judges. And lastly but not least, the Honorable Brian Sullivan, judge of the Third Circuit Court, Wayne County, elected by the State Bar of Michigan membership. Judge Sullivan also serves as secretary of the commission. One commissioner is recused from this proceeding and will not be participating, who is the Honorable Pablo Cortez, a judge of the 62A District Court in Wyoming, Kent County, elected by the Michigan District Judges. Again, I am Thomas J. Ryan, elected by the commission by the State Bar of Michigan membership. First, I would like to thank the Court of Appeals and its staff for allowing the commission to use this public hearing. The Chief Clerk of the Court of Appeals, Jerry Zimmer, and Sean Sword, the clerk for this district, the First Circuit, have been so helpful in making the arrangements to allow us to be here today. I would also like to thank Richard Corey, Kevin Scott, and Dennis David for providing security and other services. Finally, I would like to thank Nick Ostella, who assisted the commission in arranging for the live streaming of this hearing. We are now ready to proceed to the hearing. The record should reflect that disciplinary co-counsel Glenn Page will be assisting co-counsel Nicolette Horde as disciplinary counsel in this matter. Respondent Judge Brue is participating along with her attorney, Philip Thomas, Jeffrey Edison, and Christine Pajak. By way of background, on November 23rd, 2022, the commission issued formal complaint number 105 as to the respondent. Judge Brue filed an answer on December 21st, 2022. The Supreme Court appointed the Honorable Alexander Lipsey, a retired Kalamazoo County Circuit Judge, to hear the evidence. Public hearing was held over 8 days in June and July of 2025. The master issued his report pursuant to MCR 9.236 on October 14th, 2025. Disciplinary counsel filed objections to the report, and a respondent filed a response to those objections. Today is a date and time set for the public oral arguments on the objections pursuant to MCR 9.241. The commission will refrain from asking any questions during the oral arguments until I inquire of each commissioner if he or she has any questions at the conclusion of each presentation. Each side will have a total of 30 minutes to argue its case. We have a timer here with Judge Cameron, and I will let you know when you have 5 minutes of your argument left. Disciplinary counsel has the burden of proof, so you will have the opportunity to go first. If you wish to reserve time for rebuttal, please let me know at the start of your argument how much time you wish to reserve. You may begin at this time, Ms. Howard. Thank you.
Good morning.
Morning.
I would like to reserve any remaining time that I have at the conclusion of my argument for rebuttal.
Very fine. Thank you.
May it please the commission. Disciplinary counsel asks that the commission find that Judge Brue committed serious misconduct and recommend that she be removed from judicial office. At the outset, Judge Brue asked this commission to resolve two issues. We respectfully urge the commission to reject both of her claims. First, Judge Brue asserts that the commission targeted her, discriminated against her, and filed this complaint against her because of her race. There is no evidence, direct or circumstantial, that the commission's initiation of this proceeding, the investigation, the filing of formal charges, or the prosecution of this matter was motivated in any way by race. U.S. versus Armstrong held that to show unfair discrimination in a charging decision, a defendant must show that similarly situated defendants of other races could have been prosecuted, but were not. As applied to Judge Brue, that would mean that she would need to show that white judges who falsely accused someone of assault and subsequently lied about that accusation further falsely inserted racial animus into the situation and maintained that narrative for more than 3 years, was brought to the attention of the commission and subsequently not charged for misconduct. There must be an affirmative showing of clear intentional discrimination. In fact, all 4 of the white judges against whom the commission filed public complaints since 2016, Honorable Gorsuch, Brennan, Conchu, and Cusick, were charged with making false statements and therefore similarly situated to Judge Brue and Judge Nance. Judge Brue has made no affirmative showing that any white judges who even remotely resembled her situation were not charged by the commission, and she has offered no evidence of discrimination against her. Rather, the record reflects the request for investigation was generated by a very credible claim of misconduct that was explicitly supported by video evidence. The investigation followed ordinary commission procedure. Given the evidence developed during the investigation and the gravity of the misconduct, it would have been improper for the commission to not bring the public complaint. Judge Brue failed to produce substantive evidence of disparate treatment, discriminatory statements, procedural irregularities, or statistical disparities which support a conclusion of racial motivation. Judge Brue notes that the commission has brought proportionally more public complaints against African-American judges than against Caucasian judges. But without more than that fact alone, that is not evidence of wrongful racial discrimination. Additionally, Judge Brue relied on the commission's past annual reports to cite claims that she claimed were similar, but the brief summaries in the annual reports do not include enough information about each case to know the basis for not bringing public charges. Those summaries do not identify the races of any judge in that pool. Judge Brue's data does not establish racial disparity which is possibly the reason that the neutral refused to accept the defense. Most importantly, the actions of the commission have absolutely no bearing on the conduct committed by Judge Brue. Though Judge Brue's claim that the commission treated her unfairly due to her race is wrong, that does not mean that race has nothing to do with this case. The record reflects that when confronted with evidence of misconduct, Judge Brue chose to attribute Mr. Green's complaint against her, Officer Hardy's reaction to the complaint, the commission's decision to investigate, the statement of witnesses, and the commission's decision to bring a public complaint as all due to racial bias, all while denying her own misconduct. This commission must confront this troubling dimension of this case. Rather than acknowledge misunderstanding or error, respondent alleged racial targeting. That is not a minor rhetorical move, and it should not be treated as one. Racism is serious. It's a serious accusation against this commission, against law enforcement, and against Mr. Green. It deserves serious proof. But Judge Brue presented no evidence at all to support her very serious claims of racism. The record shows that this matter was prosecuted because of conduct, not because of color. When allegations of racism are used as a strategy to avoid accountability, it diminishes legitimate claims of discrimination and it undermines institutional trust. Judicial office demands restraint. It demands responsibility and integrity, especially when addressing matters as sensitive as race. Second, Judge Brue contends that the neutral did not adequately address disciplinary counsel's disclosure of her past interaction with the commission. During her testimony, Judge Brue's counsel asked her whether she had ever been the subject of discipline by the JTC. She answered no. Also contained in Judge Brue's pleading, Judge Brue represented that she had never received a letter of admonishment or a cautionary letter from the JTC. Judge Brue knew that when she was giving the distinct impression that she had not ever had any contact with the Judicial Tenure Commission, that was false. When she wrote that, she knew full well that commissioners had previously met with her to express concerns about her demeanor. The issue is candor. Respondent attempted to create the impression that the commission had no prior concerns about her conduct. That was not true. It was materially misleading. Respondent now attempts to cloak her misleading answer in confidentiality concerns. She claims that disciplinary counsel were forbidden to clarify the material fact about her prior meeting with commissioners. But confidentiality does not authorize misrepresentation. If a judge believes that confidentiality restricts disclosure, the proper course is to say so clearly, not to suggest that no prior issue ever existed. Judge Brue requests that the commission find that disciplinary counsel violated MCR 9.261A and D1 subsection A. Disciplinary counsel did not violate any confidentiality rules. Judge Brue opened the door to disclosure of her prior disciplinary history when she provided a statement that was technically true, but she knew to be misleading by suggesting that she had no negative disciplinary history. According to MCR 9.261 D3, confidentiality or privilege of any otherwise non-public disciplinary action is waived in any proceeding on a concurrent or subsequent complaint. Counsel did not divulge any details regarding Judge Brue's previous demeanor issue. Counsel's limited correction serves only to restore the integrity of the record that Judge Brue compromised, aligning with the duty to address conduct prejudicial to the administration of justice under MCR 9.202. We ask the commission to reject Judge Brue's affirmative defense and find that disciplinary counsel did not violate MCR 9.261A and D1 subsection A. Now, at first glance, respondent's misconduct may appear trivial, merely because it began regarding a disagreement over $23.34. The neutral certainly made that mistake. But respondent's misconduct was far from trivial. Judge Brue lied under oath. She falsely told law enforcement that Mr. Green assaulted her. Judge Brue lied to the commission. She shifted narratives when the evidence contradicted her. She invoked race, not as a shield against unfair discrimination, but as a sword to try to attack those who accused her of misconduct. Judge Brue's argument with Mr. Green was minor, but it was not that argument that damaged the public's faith in the judiciary. Rather, Judge Brue created the integrity crisis by her response to that argument, both at the time and to this day. Judges are human. They may misunderstand. They may overreact. They may err in judgment. That is rarely misconduct. But when those errors include dishonesty and abuse of judicial office, that is misconduct. And when the dishonesty is serious, it warrants removal. The issue becomes whether the individual can be trusted with the authority of judicial office. The public must be able to rely on a judge's word as truthful. When that trust is compromised, the whole judiciary is harmed. Several aspects of the testimony and evidence proven by a preponderance of the evidence show that Judge Brue committed judicial misconduct. Specifically, and most importantly, I would turn the commission to a few instances of very clear evidence. First, the video evidence. The video unequivocally showed that during a conversation with Mr. Green, Judge Brue aggressively grabbed at the receipt that was in his hand. This evidence is undisputed. And immediately after doing that, Judge Brue turned the tables and accused Mr. Green of assaulting her. Despite Judge Brue alleging that she was entitled to this receipt, that Mr. Green was only to possess it, and that she thought she had the opportunity to retrieve the receipt without touching Mr. Green, this evidence is the strongest and clearest. The video demonstrates a clear lack of restraint. It demonstrates the inability to problem solve and calmly handle an unfavorable situation. The video proves that Judge Brue acted inappropriately, irrespective of her explanation of a right to retrieve possession. Despite this very clear evidence, the neutral improperly concluded that Judge Brue did not falsely claim that Mr. Green assaulted her. His analysis rested in part on a conclusion that Judge Brue had every right to believe that Mr. Green had actually snatched the document from her, crumpled it up, and threw it away. This is completely untrue. It's not supported by the evidence. Anyone watching the video can clearly see that Judge Brue could not have thought that Mr. Green snatched the document from her. It was already in his hand, and she was the one that did the grabbing. The neutral found that Judge Brue could not present substantive evidence to support her claim of assault, but that missed the point completely. She couldn't support her claim because it was a fictional claim. The second strongest piece of evidence is the lip reader testimony, to include Judge Brue's own lip reader, who extracted the same exact sentence seconds after Judge Brue grabbed the receipt from Mr. Green. Immediately after the grab, Judge Brue falsely accused Mr. Green of assaulting her as charged in count 2 of the complaint. Each of the lip readers extracted some variation of the phrase, "You assaulted me. Did you just assault me?" This evidence was also supported by the testimony of Mr. Green as well as the bike shop employees. Witness testimony demonstrated that Judge Brue told Mr. Green that he, a Caucasian male, had just assaulted an African-American judge and acted with violence toward her. She also accused Mr. Green of being a racist and treating she and Judge Nance unfairly because they were Black. Having found, despite the clear evidence to the contrary, that Judge Brue could have believed that Mr. Green assaulted her, the neutral then found that Judge Brue's false reports to law enforcement were proper as well. But this finding was just as contrary to the evidence as the finding that Judge Brue could have plausibly thought that she was the victim of assault in the first place. Despite the neutral's improper conclusions regarding Judge Brue's interaction with Officer Hardy, there is no dispute, again, there is no dispute based on the evidence that Officer Hardy first spoke with Judge Brue and Judge Nance, and that he did so at length. He did not ignore the women or refuse to speak with them. Judge Brue claiming that he did so was a false statement. She had spoken to Officer Hardy for more than 10 minutes to tell her version of the argument that she had with Mr. Green, including the false claim that Mr. Green had assaulted her. Judge Brue had to know that her claim that Officer Hardy did not talk with her was false when she made it. In fact, it is important to note that Judge Brue first mentioned that Officer Hardy would not speak with her in the background section in response to the Commission's request for comment. This statement in the background section was not responsive to any question. In other words, Judge Brue wanted this false statement known as a central part of her false claim of racial animus. Similarly, Judge Nance volunteered during her sworn statement that Officer Hardy would not speak with her, and with she and Judge Brue, not in response to a specific question, but in an effort to communicate racial discrimination by Officer Hardy. This is evidence of their corroboration efforts and their false narrative. The evidence clearly establishes that Judge Brue told Mr. Green that she was absolutely a judge. The neutral failed to make a finding on this fact, but the testimony of Mr. Green reiterated that Judge Brue made statements during their conversation to include, "You are a Caucasian man and you struck a sitting African-American female judge. Do you know what's going to happen to you, a Caucasian man that's found guilty of striking an African-American female judge?" In addition to Mr. Green, bike shop employees Scott and Libby both unequivocally testified that they heard Judge Brue tell Mr. Green that she was a judge. Number 6, throughout the investigation and as part of their effort to portray themselves as the victims of racism on Mackinac Island, Judge Brue and Judge Nance falsely alleged that Officer Hardy told them to wait by the curb while he and Mr. Green watched the video. They alleged that this directive itself established that Officer Hardy was racist. In another striking similarity between their supposedly independent descriptions of the events on the island, both Judge Nance and Judge Brue claimed during the investigation that that particular phrase, "wait by the curb," had negative connotations when applied to African Americans. However, Judge Nance retreated from this narrative during the public hearing, claiming that this directive was formal and normal police procedure, a much different narrative than previously indicated. The neutral improperly concluded that Judge Brue did not violate 9.202B by refusing to respond to several questions the commission asked in a supplemental request for her comments. The neutral acknowledged that Judge Brue had not answered certain questions, but excused her refusal because the commission did not respond to Judge Brue's demand that they explain to her why the questions were necessary. The neutral found the commission's lack of response to be particularly relevant, that the questions touched upon attorney-client communications. There is no authority to support the notion that a judge can ignore a request for comments unless the commission first explains to the judge why the commission needs the judge's comments. The questions that Judge Brue refused to answer had not been asked or answered previously, and the questions were reasonable. Judge Brue simply did not like the questions, and as she mentioned during her testimony, asserted that they impugned her integrity. Her refusal to answer the questions violated MCR 9.202B. All of the above issues are detailed thoroughly and analyzed in disciplinary counsel's objections to the neutral's report. Disciplinary counsel urged this commission to find, based on the evidence, that Judge Brue committed misconduct. Consistent case law makes clear that dishonesty by a judge, particularly under oath, strikes at the core qualification for judicial office. While these cases are cited in disciplinary counsel's objections, it is important to note that in N. Ray Adams, the respondent committed perjury and made numerous misrepresentations under oath during commission proceedings. Like Judge Brue in this case, the court noted that like Judge Brue in this case, the court noted that Judge Adams had engaged in a pattern of misconduct and continues to shirk any responsibility for her wrongdoing or express any indication of remorse. The Supreme Court removed Honorable Teresa Brennan for testifying falsely under oath and making misleading statements to the commission. Courts have repeatedly held that while errors of judgment may warrant lesser sanctions, intentional misrepresentation often warrants removal because it renders the judge unfit to continue in office. The rationale is simple. A judge's credibility is indispensable, and Judge Brue compounded her lies by repeating them over years and by falsely accusing Mr. Green of assaulting her. The commission's responsibility is to measure fitness. The evidence demonstrates that respondent engaged in material dishonesty, misrepresentation, falsely accused an innocent person of a crime, and deflected rather than accepted accountability. Given the seriousness of her misconduct, the only sanction that adequately protects the judiciary is removal. Removal is not punishment. It is about preserving public trust in the courts. The authority of a judge rests not in the robe, but in the belief that the person wearing it is honest, fair, and accountable. When that belief is compromised by flagrant and serious dishonesty, continued service undermines the judiciary. For all of these reasons, disciplinary counsel respectfully requests that the commission first reject respondent's affirmative defense of racial discrimination. Second, find that disciplinary counsel did not violate any rules of confidentiality. Third, find that the evidence proves the misconduct as charged in the complaint. And last, recommend that the Supreme Court remove Judge Brue from office. The consequence must communicate to the bench, to the bar, and to the public that dishonesty by a judge is incompatible with the standards of judicial office. The public's faith in the integrity of the judiciary depends on it. Thank you.
Thank you, Ms. Hort. You have 5 minutes for a rebuttal. I will now inquire whether any commissioners have any questions for Ms. Horde, starting with Commissioner Burmeister.
I do not.
Commissioner Hankins Kane,
No questions.
Commissioner Jafar,
No question.
Commissioner Cameron,
No, thank you.
Commissioner Ison.
Just one. Is it my understanding that the grievant alleged that Judge Brue lunged at him when getting the receipt? Is that accurate?
I would want to check the exact language of the request for investigation, but I believe that that is correct.
Did you question him about that after looking at the video?
It's my understanding that there were additional conversation, additional questions with Mr. Green with regard to that, and he testified similarly at the public hearing,
That she lunged at him?
that she reached for and grabbed the receipt from him.
In his letter, he used the word lunged though, didn't he?
And I think that during the public hearing, he used a variation of lunged, grabbed, reached, all of those things.
And you indicated that a judge cannot ignore a request for comment. Is that inaccurate? Is that accurate?
Not simply that they can't ignore, but that they cannot just simply not respond to it. We sent those questions to Judge Brue. The questions were in fact reasonable. And she sent a response indicating that disciplinary counsel should explain why we asked that question.
You don't have any other cases where a judge has just ignored a question and not responded to?
I don't have any authority that supports that position, no.
Commissioner Lillard.
I have two questions. First, one of the issues that you raised is in regards to Judge Brue's allegation that the commission or that disciplinary counsel violated confidentiality with respect to her testimony regarding having no disciplinary history. Is it your assertion that her representations that she had no disciplinary history because she had never been admonished or disciplined was false?
Yes, it is our position that position that she took was in fact false. She knew that it was materially misleading when she made the statement that she had never had any previous interaction with the commission.
Is there a difference between not having any contact with the Judicial Tenure Commission and not having disciplinary action, such as an admonishment or a disciplinary action?
Thank you again for your question, Judge Lillard. What I would say is that she knew that when she represented that she had not had anything previously, that it could give the impression that she had no interaction ever, specifically with the Judicial Tenure
Asked a very
Commission.
specific question. Is there a difference between having no disciplinary action or admonishment and having no contact?
Arguably, there's a difference.
My second question is, you referenced the fact that Mr. Green made a very specific allegation against Judge Brue that she said something to him to the effect of, and I think it's also, that's in his written letter, that she basically threatened him and said, you have assaulted a Black judge, and do you know what, a Black female judge, you're a white man who's assaulted a Black female judge, and do you know what's going to happen to you or what I'm going to do to you, something to that effect. You know what part I'm talking about?
I do, yes.
And then you referenced that the two employees of the bike shop also corroborated hearing Judge Brue tell Mr. Green that she was a judge. Is that the same as them corroborating her making that very specific threat that Mr. Green didn't make initially to the police on the scene, but in his supplemental report when he flagged the police officer down later in the day?
Those are two different things. I would agree with that. But I think that they give the same distinct impression that as a result of her being a judge, she's somehow imposing her position on what can happen to him, given the fact that she's claiming that he assaulted her.
Commissioner Sullivan.
No questions.
Okay, I have no questions. Any other commissioners have anything follow up? Very good. Thank you. Thank you very much. Mr. Thomas, you may proceed.
You.
Okay, thank you.
I want to begin where Ms. Horde began, and that is regarding the affirmative defense number one that we asserted in Judge Brue's answer to the formal complaint. and affirmative defense said that she was treated differently because she was Black. Now, I heard Ms. Horde throw it out there. There's no evidence of that. She produced no evidence of that. I want to tell you, you're probably already aware of this, at least for the commission members that have been on here for some time. Your records are all confidential. Defense attorneys can't get a hold of those records. We can't go and look through them. We have no access to those records. The Michigan Supreme Court knew that when they appointed NCSC to do an audit of Judicial Tenure Commission records. But I want to tell you something. I have a little bit of an advantage over certain lawyers that practice in this area of the law. I worked at the Judicial Tenure Commission for 5 years. When I left the prosecutor's office in Wayne County, I got a job at the Judicial Tenure Commission, and I did what Glenn Page and Ms. Horde did. That was impossible. And that's why they closed their report. And I'm going to read you a couple quotes from their report when they said, look, this is what we found, but we don't know the causality of it. And I want to start with a couple quotes from the report at page 24, and I'm going to abbreviate. I have a lot of ellipses here. There's 3 paragraphs here that deal on page 24 that deal with their findings. I'm going to start at the end of the first paragraph. For cases that proceeded to full investigation, grievances against Black respondents were more likely to end in a public outcome than a dismissal or dismissal with confidential discussion compared to grievances against white judges. Moving on to the next paragraph on page 24. These findings suggest that outside of the objective factors that contribute to outcomes of the judicial grievance process, the process is working differently and leading to different outcomes in these situations for Black and white judges. Moving down to the next paragraph. The statistical analysis methods used here explore the strength and direction of association of variable, but available data was not appropriate for additional methods that could better assess causality. The various judges groups, Black Women Lawyers of Michigan, Association of Black Judges of Michigan, the ACLU, the NAACP. There were 18 ministers, some of them are here today, and entrepreneurs who wrote to the Michigan Supreme Court asking that an audit be conducted. Look, when Demetria Taylor Coleman testified before Judge Lipsey, when she testified, what she said was, look, I wrote this letter at the direction of our group to the Supreme Court. I took part in it. I'm one of the lawyers that did an investigation going back to 2008. And when you go back to 2008, 56% of the judges in Michigan that were prosecuted formally, publicly, by the Judicial Tenure Commission were Black. Now, you want to know what the kicker is? I assume you know it from all the things we've submitted to you. About 16% of the judges in the state of Michigan are Black. 16%, yet they were the subject of 56% of the formal complaints. She also testified that if you moved up to 2020 and went back and checked out what the races were of individual judges that were prosecuted by the Judicial Tenure Commission, the ratio was 80% to 20%. 80% of the judges were Black, 20% were white. There's a disparity there. I think if anything, you are probably as aware or more aware than just about anybody involved in the system of justice in Michigan. So what NCSC did is they said, look, there's got to be further work done. Further investigation has to be done. But what you need to know is Jeff, Christine, and we don't have access to the records at the Judicial Tenure Commission. Just like NCSC didn't have access to the records, they had limited access to statistical information. That's what they based it on. Read over the 25-page phase 2 report. That's what they based their decision on. So we believe that by putting the NCSC report in, and we believe that by putting Judge Brue's testimony in, and by putting Demetria Taylor Coleman's testimony in, we believe there was strong evidence of racial disparity, discrimination against Black judges when compared to white judges. And the bottom line of all that is this. that discrimination doesn't just affect black judges. That really affects the system. That affects how people view the system. That affects how white lawyers and black lawyers and white judges and black judges view the system. So we believe that there was good cause for the master to enter the finding that he did at the end of his report. This is what he said. Look, essentially, he said, I recommended dismissal of all these charges, so I don't have to get to affirmative defense number one. I don't have to deal with that. But he said, I'm telling you, he said, he indicated that that evidence raised significant questions about disciplinary counsel's prosecutorial discretion that was exercised in this matter. Read it over. It's the last sentence of Judge Lipsy's report. He didn't decline because he felt it was irrelevant. He didn't decline because he didn't want to devote the time to it. He just said, look, with what I have to work on and with what my responsibilities are regarding hearing allegations of the formal complaint and rendering a decision, I don't have to do that. So I would tell you, I really believe that my client was discriminated against. She was discriminated against in the investigatory process. And let me tell you why I say that. You know, and Ms. Hort, I think, acknowledged, we don't have access. When we look up cautionary letters and letters of admonishment, we don't have access to the judge's name. We just go by your public reports that you submit at the end of each year. There was a judge in 2015. Don't know the race of that judge, but that judge got in an argument at a festival with festival workers. He used vulgar language. That's the wording that this commission used in its letter of admonishment. And he threw a can, a beer can, at festival workers. That lawyer was admonished. That's 2015. Now I'm telling you, if I had the authority, if I had the ability to find out that judge's race, I would not be surprised if that judge was white, but I can't represent that to you. But I want to tell you, when we get into talking about the different letters of admonishment and cautionary letters that have been issued, you've issued admonishments and letters of caution to judges that have done far worse than anything that Judge Brue has been accused of. The next thing I want to talk about is Ms. Hord's discussion regarding our allegations that disciplinary counsel violated MCR 9.216 A and D. Let me tell you what happened at the hearing. I was there. I asked the question, look up the transcript. I asked her if she had ever been admonished or cautioned. I never asked a question about whether she ever had any contact with the Judicial Tenure Commission. I never asked a question about whether she had ever been brought in for some type of discussion with a commission member. That was one commission member that met with her in 2015, and the matter was resolved. She was never admonished. She was never cautioned. Now, during her argument, I heard Ms. Hord implying that I asked questions regarding whether she had ever had any contact or whether she had ever been disciplined. My questions were, have you ever been admonished or received a cautionary letter? She answered no. They never cross-examined her on that at the hearing. They never even brought that up at the hearing. They never brought that up until it was time for submitting proposed findings of fact and conclusions of law to the master, to Judge Lipsy. They brought it up, and when they wrote the letter to me, they said, not the letter, the objections, they said, well, that was technically correct, that she had never been admonished or never been cautioned. We believe that her having met with the commission member regarding certain matters relating to her service as a judge, we believe that was encompassed by it. Look, we're lawyers. Let's not play games here. Lawyers tailor questions when they ask their client questions when they're on the stand. They had the right to cross-examine my client at the time. I would have been able to object. I would have been able to object before the master. I would say, wait a second. I never brought that up. That would be a violation of the Judicial Tenure Commission court rules. They didn't do it at the time. Why they didn't do it, I don't know. If you really want to know the truth, I think that they probably didn't know about it. I think that after the hearing was closed, They went and checked the record to see if she had ever been admonished or ever cautioned. But for whatever reason, they didn't cross-examine her. The next thing that, the next point that Miss Horde raised concerned my client's reaction to Mr. Green and the staff there on the island, to her feelings, her belief, her saying that she was being subjected to racist behavior. Around the time that I answered the 28-day letter on behalf of Judge Brue, it was around 2/22. It was right near the tail end of COVID. There were two cases in the news. Then I attached newspaper clippings concerning two cases involving African Americans and how they were treated when they went to banks. One of the individuals was Ryan Coogler, the director of the movie Black Panther. He's a young, dapper guy. He walked into a bank and he asked to cash a check for $10,000. He had an account there. And he said that he needed the $10,000 because he had to pay medical assistance for his family members. I guess somebody was sick and they had to have in-home care, what have you. I don't know all the details, but I'm just telling you what he said. The individual working at the bank got a couple other individuals that were working at the bank, and they made a determination that Mr. Coogler was trying to commit a fraud, was trying to commit a robbery, was one of the terms that they used when the bank teller actually called the other people in. And Mr. Coogler ended up being arrested, handcuffed, and taken out to the police officers because he went into his bank to cash a large check. That's what happens to Black people. That's what happens. Do I believe that any of the staff members at the bank use the N-word or something along those lines? I don't. This is how racism works in the third millennium. People don't do that. People carry out their actions in a prejudiced way, and it's up to the Black person to try to discern how they're being treated and why they're being treated in that fashion. The second matter that I brought to your attention concerned the woman. She was 71 at the time. Her name was Lizzie Pugh. She won $20,000 at the Soaring Eagles Casino. And she went into a bank. She wanted to open up an account so that she could deposit the check and cash the check. They ended up accusing her of fraud. 71-year-old woman had a valid check from a casino, and they wouldn't cash it. They told her she was committing a fraud, and they actually refused to give her the check back. They said, "We're not giving that check back to you." She had to threaten to call the police. She had to call the police to get her check back. She's a Black woman, elderly woman, won some money and wanted to cash a check. That's how racism works in the third millennium. People are sharp. You use the N-word, you get in trouble. There's other codes you use. What Green told Judge Nance when she asked for an accommodation, what he said to Judge Nance and to Judge Brue: "You're not getting a free ride. I know how you guys operate." That's a quote. That's what he said. And he also accused Judge Brue of credit card fraud, because when she went up and gave him her credit card, whoever populated that computer field, apparently one of the employees, they got her name in wrong. Her last name, I think, was listed as Demetria. So he couldn't find the name Brue. He treated her very, very shabbily. They were treated shabbily from the moment they arrived. All Judge Nance had was a little problem with her bike. It wouldn't shift. She couldn't enjoy the ride. In the request for investigation, Green says that they rode all around the island. They didn't. They never got to finish their trip. She was walking, and Judge Brue would ride her bike for a while and then get off and walk alongside Judge Nance. These women were treated. They were treated exactly how Miss Pugh was treated. They were treated exactly how Mr. Coogler was treated. You're dealing with a county up there, predominantly white, not many Black people up there, not many Black customers at these establishments. You get in there and you look at what he did. He looked at them with disdain. Judge Brue, I didn't hear an admission from Ms. Horde on this. She never contested the charge for her bike. Her bike charge would have been about $11.17. She never contested that. He admitted that she wanted to pay for it. Judge Nance felt that she didn't get what they had paid for, and she wanted an accommodation. She never said she wanted it for free. Not one time did she ever say that, nor did Judge Brue say that. When asked why he didn't accept Judge Brue's money, her $11.17, when he was asked that question, he said, it wasn't the full amount for the bill. That's the attitude that this man had. So let's clear the decks here and let's say this. I really believe that at some point in time, you may have already done it. I don't know. I really hope that at some point, at least one or more members of the commission would read over Mr. Green's testimony, especially his cross-examination by Jeff. It's just very, very enlightening. He did some things on that island that day. And let me just tell you this about the police officers that were there. He knew the police officers. Judge Brue and Judge Nance didn't know him. The officers testified that on hot days when they were thirsty, he would give them bottles of water. They all knew him on a first name basis. These two judges were treated as the outsiders. The police officers were treated as the insiders. What you had happen when Officer Hardy arrived, he arrived after the fact. He did not see what happened. And unless you have looked at the 1 minute and 9 second tape that Mr. Green showed to Officer Hardy when they went back into his office, you really don't know what happened that day. You hear me arguing one thing, you hear Ms. Ford arguing another thing. Let me tell you, on that video, the video that was sent to me when I was answering the request for investigation on behalf of Judge Brue, and her and I were sitting down looking at it, it was what I called at the time a snippet, SNIPPET, 1 minute and 9 seconds long. And the critical part of it was this: Green gave us and he gave the police a video that had that receipt in Green's hand when the video started. When you start that video up and you look at it, that receipt is in Green's hand. What Green never told the officers, and what that video didn't depict, was that was Judge Brue's receipt that she was given at the time that she rented the bikes. She took that out of her pocket. That's the receipt that she asked multiple times for Green to return to her. I want to tell you, we don't believe that the lip reader testimony should have been admitted. It never been admitted by any court in the state of Michigan, but you requested it, so that the ship has sailed. I guess you're going to review that. But when you're reviewing that, please look at this. In that video, you will see the various lip readers stating that she asked for her receipt back. That's evidence that I didn't want to admit it, that I fought against it, was put on a separate record. So there is evidence to support her claim. So what do you have? You have Judge Nance testifying to certain matters, describing what happened. You have Judge Brue doing the same. And then you have Green. And let me tell you about the two witnesses that testified. The young man, Jared Scott, he worked for Green for about 3 summers. He was going to school, go work at summers over there. The other one, this guy, Gunnar Libby. Gunnar Libby has worked for Green since he was 14 years old, and he was in his early 20s at the time our hearing took place. His mother was a business partner with Mr. Green in multiple ventures on the island. Both very, very wealthy people, well-to-do people. I believe Green said he had about 10 businesses that he owned on the island. These people were used to having it their own way. Gunnar Libby tried to defend Mr. Green. Scott, not so much. I think he was really trying to the best of his memory, but he just got things wrong and he got tripped up.
Mr. Thomas, excuse me. So you have 5 minutes left. I know you technically asked for 5 minutes rebuttal, even though you're don't have the preponderance. So if you want to continue and finish your 5 minutes, that's great, or you could not, but.
Well, there's so much that I didn't cover. I tell you what.
Why don't you just finish your 5 minutes and let me.
Okay, I'm going to reserve my 5 minutes.
Well, no, you've got 30 minutes, so you can use it how you want to, but you don't have the preponderance. So either can finish now and use your full 30, and we'll let Ms. Hort save her 5 because she's already saved it. the other preponderance, or you can do whatever you want, but you have 5 minutes left.
My co-counsel said she timed me at 20 minutes. I'm not disputing. I'm just
Well,
saying.
I've got a timer up here that I'm going with.
Okay, well, then we go by your
Okay.
timer. Well, I think I'm just going to keep going, and I want to thank you very much for the reminder.
All right, no problem.
All right. The videos, I've talked to you about that. You got to take a look at the video that was provided. And then you also need to know that from the start, going back to the time when I represented Judge Nance at a sworn statement, I had been clamoring about additional video. I knew that there had to be additional video. That shop had multiple cameras on it. And prior to my client ever even having to answer the request for investigation, the Judicial Tenure Commission staff got in about another 25 or 30 minutes of video. They never gave it to me. I answered, and Judge Brue answered with me, the request for investigation with only access to one little snippet, not 1 minute and 9 seconds of the video. That was critical. That was critical to not only Judge Brue, that was critical to Judge Nance, that was critical to her attorney. We were entitled to that additional video. In my answer to the request for investigation, I complained to you as a group that my client had to answer the request for investigation with only access to 1 minute and 9 seconds of video. We knew that there had to be more. We do. And in fact, there was more. It came into possession of your staff a few weeks later, September of 2020. We had to answer the request for investigation in November. That was held back from us. Do I believe that you necessarily made a determination to hold that evidence back? I don't know. But we never got that evidence until 8 months later, running close in time with us having to answer the 28-day letter. You heard Ms. Howard talk a lot about dishonesty and false answers that were given to the commission during the course of the investigation. Let me tell you this. That was all regarding the answer to the request for investigation. When we got the additional video in time to answer the 28-day letter, that formal complaint doesn't charge my client with making even one misrepresentation. And most spectacularly, we knew when we got the evidence, the additional tapes, we knew conclusively that my client's memory was correct, that the receipt was hers, and she was trying to recover her chattel. And he did. Green said in the request for investigation, she lunged for it. I got to tell you, the Judge Lipsy said she reached for it. She might have lunged for it, but it was really reaching for it. And that's what was done. So with all that, you need to know there's other missing footage. We've talked about this at length in our response. The officers had body cameras on. You would not have to face a challenge from each side regarding what was said by officers and how they acted if the officers' video recorders were working. And Michigan has a compiled law statute, and it says that videos have to be retained for 30 days, but if there's some type of action pending, the tapes have to be retained until the end of that investigation or that proceeding, whatever it is. So what I want to impress upon you is this. It's kind of offensive to stand here and have to defend Judge Brue's word against officers' words who had body cameras on, but both of them said they weren't working. They weren't working. Actually, Police Officer Hardy said he checked his body camera that day in the morning, and he said it was working, but we don't have it. We've never had it. The other thing that I want to point out, what I'd really like to direct my last few minutes to, the cases that Ms. Hord referenced in support of her position that Judge Brue should be removed from office. Let me tell you about them. In the James case, she wasn't just charged with lying or making misrepresentations to the commission. The Supreme Court found that she abused this monetary fund in her court that was supposed to be paid over to victims of crimes. Justice Markman said she used it as a personal piggy bank. That's the first case she cited in support of her argument. It might have been the second case that Judge Brue should be removed. And Judge Brennan, she wasn't just removed from office. You didn't recommend removal from office just because she made a misrepresentation in answer to a request for investigation. She lied under oath in her divorce case. She had been having a years-long relationship with a detective, and she presided over a criminal case involving him. And the court in that case said this: the court's overriding duty in judicial discipline cases is to treat equivalent cases in an equivalent manner and an inequivalent case in a proportionate manner. There is absolutely no way that anybody could draw a comparison between what Judge Brue is accused of and has been accused of for 6.5 years now and what Brennan did. In the McCree case, he was having an affair with a litigant and a complaining witness in a case. The relationship expanded out to his office. It was just really a mess. He snuck her cell phone into the court for her and gave it to her and was texting back and forth with her during a hearing in her case. And after the breakup, he was found to have lied to the Wayne County Prosecutor's Office in an attempt to get a personal protection order against the woman that he had had the affair with. So for all those reasons, I really don't believe that any of the cases that have been cited by Ms. Hort come close to paralleling the conduct that you have here. In addition, in our response, we've traced out a path through admonishments and cautions that this commission has handed down to judges over the last several years. I think we pick up right around 21, 22, 23, and 1 in 24. A judge was cautioned for locking up someone for 3 days for contempt. That's far worse than what Judge Brue allegedly did. In your annual report from 223, a judge was privately cautioned for depriving a litigant of her freedom, and appears, and she was a female, and I guess you said there appeared to have been evidence of gender bias. Judge Lasada, we talked about that in our response. The admonishment letter that he was issued, it cited at length in our response. It took about 2 or 3 pages to do so. He did a myriad of things that were far worse than anything that Judge Brue comes close to having done. And then I've already mentioned the one where the individual, the judge in 2015, this is in your JTC annual report, 2015, page 16. How can you compare what that judge did that you admonished him for? Arguing with festival workers, using vulgarities and throwing a beer can at one. How does that compare to what Judge Brue did? Even if one assumes that a lot of the allegations that Green have said, which we don't agree with any of them, I really believe that you got to. In the old days when I was working at the commission, they would generally appoint 1 or 2 members of the commission to review a transcript. Somebody's got to take a look at that cross-examination transcript of Mr. Green. Note this, no matter what I say, it can equate with the 3 points in Judge Lipsy's report where he says that he found Green's testimony to lack credibility. That's what he heard, the testimony of all these witnesses. And he handed down an opinion based upon what he heard and what he saw in his courtroom. Am I out of time or do I still have time?
Another minute.
Another minute? Okay. Well, the last minute, I apologize.
Well, look at your
Look.
notes for just in full transparency. Your timekeeper was correct when I said you had 5 minutes early at 10, so I apologize for that. But so now you've had your 9, so take your minute and
Okay.
You'll be
All
all
right.
set.
Okay. I want to turn to the 7 factors for determining an appropriate level of discipline. Number 1, misconduct. Misconduct that is part of a pattern or practice is more serious than an isolated incident of misconduct. That's number 1. That doesn't even apply here. This was at one incident that occurred on Mackinac Island. I heard all this stuff about lying in answers to requests for investigations and that all those materials were submitted to Judge Lipsy. He didn't buy it. He didn't buy what they were saying. Misconduct on the bench, item number 2, misconduct on the bench is usually more serious than the same misconduct off the bench. This was off the bench misconduct. None of these factors really apply here unless you believe for 1 minute that when Judge Brue was on that island, she lied to the officers, or when she answered her request for investigation, she lied. And the most important thing I want to impress upon you in my closing seconds here is this. Mr. Green testified at the hearing under oath that it was not Judge Brue who told him that she was a judge. He said that it was Judge Nance. He was talking to the two witnesses together at times. You look at the videos, you'll see he was talking to them separately at times. He testified under oath. So the best information I have here to contradict what he said in his request for investigation and to rebut what Ms. Horde said, my client never told Green that she was a judge. That was conveyed to him by Judge Nance. And I will tell you this, I don't represent Judge Nance. She has her attorneys here and she's here today. But what I will say is this, I think that what she was doing is she was trying to calm the waters. I really do. You know, he was treating them like they were criminals. So when you're treated like a criminal, if you got a decent job, you might say, well, you know, I'm a union electrician. I'm a union plumber. If you're a judge, you might say you're a judge. Judge Brue didn't do that. Judge Nance wanted him to know she's not a criminal. Don't accuse her of credit card fraud. Don't ask her if she used a card that belonged to somebody else. She wouldn't do that. We're respectable people. That's why that information was conveyed to Green by Judge Nance. And it wasn't until Judge Brue was talking to Trooper Bergsma, who they perceived as a supervisor. Because you got to remember something. What happened on that island, and I noticed how it was skirted over, it wasn't mentioned. What happened on that island alarmed Judge Nance and alarmed Judge Brue so much that Judge Nance called for a supervisor. And I provided documentation of that to the Judicial Tenure Commission. They never challenged that at the hearing, at our hearing. They never challenged it. To my knowledge, they never challenged it at Judge Bruce here. I actually provided the phone record showing that she made that call. Something happened on that island that was inappropriate. The something that happened was something similar to what happened to Mr. Kugler and to what happened to Ms. Pugh when they went in their banks to cash checks. This whole concept that the disciplinary council came up with, that a person, that a Black person can't just rely on substantive feelings, what they think is happening, how they think they're being treated. They say there's got to be some type of objective argument. You want to know an objective argument? Judge Nance was so scared and so worried about what was going on, she called for a supervisor. And when Trooper Bergsma got there, an older man, he was white, but he was an older man, much calmer than these other two officers. He wanted to work things out. He not only did Judge Lipsy say that this was a trivial matter. When Bergsma arrived on the scene, he told the two judges, he said, come on, this is a trivial matter. Let me work this out. I'm going to work it out. And he did. He did so.
Thank you, Mr. Phil. Thank you, Mr. Thomas. I'll ask any commissioners whether they have a question of Mr. Thomas or not. Mr. Burmeister, Commissioner Burmeister? Commissioner Kane?
No.
Commissioner Jafar?
Do not.
I don't have any at this point. Commissioner Ison?
You gave an analogy of the judge at the festival throwing beer and yelling at people.
Yes.
And you recognize that there's more than just the conduct, because the conduct here would be, if you will, grabbing the receipt or whatever that misconduct was, right? So that was with the judge with the beer, that's the conduct there, right? And some of the alleged conduct here is what happened with the grabbing of the receipt, right?
Well, you know, we cited case law to you in our response that talks about an individual's right to retain their chattels.
I'm just saying what the alleged conduct is.
The alleged
You agree with
conduct
that,
was
right?
that, yeah, but we think we disproved that. Judge Lipsy said she reached for it.
I understand, but you also agree that there's that allegation of credibility that wasn't present in the other case, right?
I don't know. I don't know anything
You
about
don't
that.
know,
When you, in your reports, your annual reports, when you cite a cautionary letter, there is just scant information given, sometimes 2 sentences, 3. I don't know those facts. I wish I did.
Okay, all right. But if the commission feels that the credibility of the judge is at the core of that job, do you think that the commission would ignore that in a case where that had happened and just talk about somebody yelling at somebody at a festival?
Well,
You were on the commission. Do you think that?
well, I tell you what, I don't believe that there's credible evidence that she's lied about anything. I really don't. When
That's
you,
not the question. You understand the question?
no, I'm honestly trying to, you're saying that in the beer can case, there was more than just the beer can and the vulgar.
I'm saying if there was issues of credibility, that the judge had lied about something, you think that the commission would have admonished him about yelling and throwing a beer and not about lying?
Well, or in the alternative, they may have found that he didn't lie, because the Servas case that's cited in our response specifically says it's not just enough to show that something that a judge said was inaccurate. There has to be an intention to mislead. And Judge Lipsey talked about that in his report on misconduct. So I would say this, there's a good possibility, maybe he was accused of lying. I don't know, because your annual report didn't say that. But what I can tell you is under case law established by the Michigan Supreme Court in Serva, not everything that a judge says that may turn out to be inaccurate is necessarily an intentional misrepresentation. So I don't know. But if you're asking me, could there have been something else? There could have been. There might not have been.
And you think that if it was lying, then the commission would ignore it? Is that your position?
I'm not saying that.
Okay.
I'm not saying that.
Okay, you also spent a lot of time talking about the audit, and you talked about the formal complaint. Do you know whether more Black judges, there are more RFIs against Black judges than white judges? That would kind of speak to the disparity to some degree.
Well, I think that generically over the years, I think that has kind of been the commission's position. And I
Not the
think that,
commission position, just whether or not it is accurate. Are there more complaints filed against Black judges than white judges?
I can't say that. I don't know. All of your records are confidential. I can't get to that information. I can't.
Thank you.
Commissioner Lillard,
I have no question.
Commissioner Sullivan?
No question.
I have no questions. Thank you, Mr. Thomas.
Thank you.
And Ms. Ford, you have 5 minutes of rebuttal left. Thank you.
Thank you. I'm gonna first start by addressing the statistical review. It's consistently been referred to as an audit. An audit is very different than an actual statistical review. It is my understanding in the position of disciplinary counsel that what happened was a statistical review. An audit would open up files, it would go into specific case details. That is not what took place here. This was for numbers and statistical analysis only. Additionally, in the NCSC report, there is not a deeper dive as to why more cases go to public hearing than not. There's no reference to the fact that ultimately the decision rests with the judge as to whether or not they want to go to public hearing. There's no reference to the decision of the attorney or the interaction with the judge and their attorney and what they decide to do. Ultimately, again, that decision rests with the judge. So I want us to just take a moment and just understand that the NCSC review was statistical only in nature, and it was not, in fact, an audit, even though we continue to call it such. As well as that, the question with regard to whether or not Judge Brue had had any contact with the JTC, that was referenced during the public hearing, but it was also referenced in her findings of fact and conclusions of law. She did represent, which was a material misrepresentation, again, technically true, but not completely accurate. So I just want to make sure that it was said as well in the documents as well as in the public hearing. Additionally, I think it's very important to note that there is no evidence to support a claim that Mr. Green ever stated to Judge Brue that he was accusing her of credit card fraud. The record will reflect, the transcripts will show, the testimony and evidence prove that Mr. Green was trying to locate Judge Brue's information in his computer system. And he was doing that by trying to read what was actually on her credit card and asking her for her name and for her information. It did not populate in his system the way that ordinarily names go in the system. So he had to further ask her questions. He testified specifically that he never accused her of credit card fraud. Additionally, Mr. Thomas referenced the fact that Judge Brue did not pay the full amount for the bill and that Mr. Green did not accept the full amount for the bill. I think that that is important because I think it relates to this argument of credit card fraud or the willingness to pay, but not the willingness to accept the money. There will be no business owner that would not accept their payment when the issue is payment for the bikes. I think that very easily, Judge Nance and Judge Brue could have simply paid and walked away and the situation could have been concluded. To say and represent that Mr. Green did not want to accept their payment seems a little bit contrary to normal and ordinary business practice. Additionally, Mr. Thomas referenced Mr. Officer Hardy and Mr. Green going to watch the video. I would like for the commission to consider why it would be necessary for them to go and watch video unless there was some accusation that needed to be resolved. As I mentioned in my remarks initially, Judge Brue accused Mr. Green of assault. When the officer arrived, he was investigating what took place. In order to further determine what took place, he did go and watch the video. So to say that there was no accusation of assault is, again, not true. Mr. Thomas mentioned missing footage. I want it to be very clear for the commission, as I believe it has been thoroughly and completely briefed with regard to the video, the body cam. All of the video that is in the possession and that was in the possession of disciplinary counsel has been turned over. There's no missing video from the standpoint of disciplinary counsel. As Mr. Thomas mentioned, there was no body cam footage. The officer testified that they had problems with their body cam. By the end of the day, sometimes it didn't work. There was not body cam footage that was subsequently withheld. The body cam footage did not exist. And finally, I would just like to remind the commission and reiterate that the case is not simply about the interaction between Judge Brue and Mr. Green. I understand that Mr. Thomas spent quite a deal of time talking about race and racism, as we know that is very real in our country. We understand that, and we should understand that as Black people, when certain situations happen, you go into a restaurant, you go into a store, yes, there's absolutely the possibility that you could be treated differently as a result of your race. I'm not suggesting that that's right. I'm not suggesting that that's okay. But the issue here is a judge held to a higher standard and what they do as a result of whatever this feeling is, irrespective of what is objectively evident to them. I think that Judge Brue claiming that Mr. Green was racist upon seconds of meeting him is extremely problematic, but it's further problematic that because of how she felt in that situation, she then went further and accused Mr. Green of racism, as well as accused him of assault. We have to take into consideration that an innocent man could have been charged and subsequently convicted had there not been any video evidence to negate what it was that Judge Brue was saying about him.
Thank you, Ms. Hort. Does any commissioner have any questions of Ms. Hort? Any further questions? Okay, thank you very much. So there being nothing further, the commission will take this matter under advisement and will issue a written decision and recommendation. That decision and recommendation will be a public statement and it will be posted on the commission's website. The commission thanks counsel and the court again for their time today and their well-written briefs and their thoughtful arguments here today. There will be a second hearing, which will begin in approximately 15 minutes. I am recused on that matter. So this matter, however, is adjourned at this time. Thank you very much. Have a great day.
All right.